episode of Surviving the Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, SCS Nation? Welcome to Surviving the Survivor. It is the show that brings you the very best guests in all of true crime on trending criminal cases. And Bryan Kohberger has been in the news since November of 2022, I want to say. November 13th. I hope I have the year right there. It's 22 or 23, but I believe it's 2022. And I should know that. But a little delirious. We've been following the Lori Vallow Daybell trial all day and pivoting over to this. We have the best guest in true crime, Sky Lazaro, joining us from the great state of Utah. She loves horses, and so do I. You see her horsey over her right shoulder, and she is a formidable criminal defense attorney, perhaps best known to STS Nation as the former defense attorney for Corey Richens. And I was planning to go to that trial, but it was just continued, which I will ask about shortly. And next up, Tara Malik, who is a defense attorney out of Boise, Idaho. That is not a green screen behind her. That is the beautiful state of Idaho. And she travels around the state doing legal work and is also a former prosecutor. And Greg Skordas will hop in here momentarily. He ran for Attorney General of Utah. He's been an attorney for 40 years, starting as a public defender. But today, Bryan Kohberger's legal team, they were pushing back hard in court. They did reveal once again that they're planning to use his autism diagnosis in the case, but not as an excuse, potentially as mitigating evidence in the death penalty phase. So we're going to discuss what that means specifically. And then another major development in this hearing today, we're finding out that Bryan Kohberger's family, specifically likely his father and sister, will be called to testify against him. The defense had some choice words about that and basically said, look, they don't want to testify against him. They love him and support him, but they will be called, it appears like, from the state. And then they came back and said, well, if the state is going to call them, they need to subpoena them. And so what does all that mean? We're about to dig deep into it. But Sky Lazaro, I got to ask you, yes, they are fighting. Bryan's team is relentless. But so, Sky, I know you're not on the case anymore, but I had my, of course, my flight booked and my hotel reserved in Park City for Corey Richens, and they wanted a change of venue. They didn't get it. But my question is, how come the case, how come the trial is continued as a result of that now?
It's my understanding the defense intends or did file an appeal to the Utah Court of Appeals on that issue and requested that the case be stayed pending that decision. So that was the reason for the continuance, was the interlocutory appeal on the change of venue motion.
And so in English, what does this mean for her trial? Like, when do you think we will see her go to trial?
I mean, I guess the question is, or the answer is, it depends. The Court of Appeals can decline to take the issue. If they do that, they'll just issue a 2-sentence ruling that says, we're not going to take this issue, send it back down for further scheduling. If they do take the issue up, then it's going to need to be fully briefed by both sides and, probably oral arguments be heard on it. So, these appeals don't go fast. I think you're looking at a year, 18 months, 2 years.
If it does go through the appeals process.
If it goes through the entire appeal process, it really could delay things for a considerable amount of time.
Wow. If I was her, I would not want that. I would want to get my, out of jail. But if she's going to sit in jail as this all plays out,
she will. I mean, I don't. Under our bail statute, you have to have a change in circumstances to trigger a new detention hearing or be released. Now, time can certainly play a factor in that, but, she chooses to file the interlock, that's probably going to be attributed to her, not the state. So I don't foresee that being a basis for Judge Mrazek letting her out, honestly.
We've got the Terminator backstage. I'm about to let him in. There we go. Greg Skordas. I like the sunglasses. I already introduced you, Greg. Thank you all for coming on early. We were scheduled to do this a little bit later, but Lori Vallow's court day has ended early. So Tara Malik, one of the interesting things that came out of this hearing, it was a prolonged hearing today. Honestly, it could still be going on. I'm not 1,000% sure if anyone in STS.
It is.
It is still going.
It's still going. Yeah.
Okay. So
or it was a couple of minutes ago.
Okay. And do we know, Tara, do you happen to know if it's continuing into tomorrow? Because they're just taking up motion after motion about what evidence will be admissible, basically.
Yeah, I think they may go into tomorrow. I'm not sure. I had to drop off watching it for a little bit there. So they were, as of 10 minutes ago, they were on the topic of whether the death penalty should be taken off the table as a discovery sanction. So that was the motion in limine they were arguing.
Okay. So one of the things that came up today that I know is big, it just ended. Thank you, COE. But one of the issues, Greg Skordas at play, we found out about this fairly recently, that the defense claims he has a diagnosis, Bryan Kohberger does, of autism, that he is on the spectrum. So the defense today argued that Bryan Kohberger's autism should not be used as an aggravating factor at sentencing if convicted. Prosecution, the government came out and said that they agree, actually, that they don't intend to use it as an aggravating factor, but they might use it as a mitigating factor instead. In English, not in legal terms, what does this all mean for Bryan Kohberger?
Well, if anything, Joel, I think it's mitigating. It doesn't necessarily excuse or justify anything that he did, but it might explain his behavior in ways that a jury might take into account in determining what the appropriate sanction would be. So any psychological issue or diagnosis would be mitigating, I think, when you're talking about a crime that required such planning and preparation and what we call intent. So, yeah, I think I'm surprised the prosecution would say that they would use it as mitigating. The defense certainly will, though.
Yeah. Sky, I want to just pick up on that a little bit more, but obviously, you know, we always talk about Bryan Kohberger, but the victims here are really who matter. And that, of course, is Kaylee Gonzalez. Her parents were in court today. They've been at a lot of the court hearings. You've got Maddie Mogan. You know, they found that unknown male DNA under her fingernails. That came up today as well. Xana Kernodle and, of course, Ethan Chapin. Xana and Ethan were dating at the time of this horrific killing. Jury selection is slated for, I think, the last day of July into August, with the trial set to start August 11th. I will be there. STS will be there, and we'll bring you that live. But Sky, to you, the defense, and I quote here, said that they claim that Bryan Kohberger's quote-unquote awkward mannerisms mean nothing legally and should not be weaponized by prosecutors. What's, I guess, really at play here? I mean, it sounds like the state is not digging their heels in and saying, yeah, we're going to say that this guy is on the spectrum and that's part of the reason. And so what is, like, I guess, what is the argument about if the state appears to be agreeing with the defense, but the defense is still fighting on his behalf here?
Yeah, I mean, I think it's stuff you want to bring up, especially if somebody has some awkward ways about him, because everybody responds differently to different situations. But if there were some weird things he did, you know, after he was arrested, some things that we've seen on TV, you know, the way he answered questions, you know, whatever it is, I think what the defense is getting at is they don't want it weaponized against him, you know, the state being able to say, like, this is evidence or consciousness of guilt, which you can't say, but allude to, you know, and to be able to explain on the mitigation side why he may have reacted that way or, you know, done things the way he did or said off-color things or, whatever it is.
Yeah. Well, Tara, so Judge Hippler ruled on some of these things, said he was going to take some under advisement. So not everything was sort of agreed upon or decided upon by the judge, but Judge Hippler did say that he agrees. He is saying that autism will not be an aggravating factor if the case goes to the penalty phase. So I still am not 1,000% clear, but is this basically just a sort of a concession to the defense? Yeah, this won't be used at trial, but if it goes to the death penalty phase, they can use it, I guess, as a mitigating factor, but not an aggravating factor still.
Not exactly. So in the death penalty phase, in the penalty phase of the trial, so it's, again, we've got part one, which is the guilt phase. Part two is the penalty phase. The prosecution is going to have to put on evidence that the type of crime that this was meets the statutory requirements or aggravating factors to certify or qualify it to be a death penalty case, and have this jury say that the ultimate penalty here should be death. What the judge was doing and what was being discussed back and forth between the parties was how and if this determination or this categorization or whatever you want to call it of Bryan Kohberger's mental health issue, if he has any, the diagnosis of having autism and whether he's on the spectrum, could be used as an aggravating factor. And the state came out and said, no, that's not what we're going to be using as an aggravating factor. It was Mr. Nye, I think, who argued that and said, of all the stuff that we have, this ain't it. We're not going to be using this. The defense came back and said, well, we want to have the ability to explain some odd behaviors or quirks that he has. One example that they gave that I had heard for the first time during this hearing was his tendency to perhaps lurk or stand in doorways and stare at people, or be in a conversation for a longer period of time, talk longer than the person on the receiving end wanted to engage in that conversation. So in this hearing, they were kind of hinting at, to us, and I think the direction that they're going to go with this. So some of these behaviors, they wanted the court to have a very specific order to say that the state could not use particular characteristics and behaviors identified in whatever expert they have disclosed, an expert report they disclosed, as aggravating factors. The judge didn't go so broad. I mean, he goes, I think there's an agreement here that, the state is not going to be using this diagnoses as an aggravating factor. I can give a general instruction, jury instruction about how that shouldn't come into play as an aggravating factor as well. I think it's a deeper issue. I think what we're likely going to see is the state's going to probably put on evidence about how intentional and planned this may have been. I'm just guessing here, and use things like, lurking behavior. I'm just throwing out examples. That could be it. That could be what the defense is trying to get ahead of and say, no, those are related to his diagnoses. Those are not, this doesn't show his plan or his knowledge or his, whatever it is, his intent to go through with these murders. So anyways, that's just my speculation based on what was said in court today.
Yeah. Well, this is pretty.
I'm sorry, Joel.
Yeah.
How could autism be an aggravating factor? I guess I don't understand that.
I was going to ask the same question. I
don't think it is. I mean, it's not.
It could possibly be.
Yeah, and it's not. I mean, I think so. In the briefs on this motion in limine on this particular issue, the cases that were cited by the defense or cases that had to do, one in particular was a case of someone with a very low IQ. And that went all the way up to the Supreme Court about whether you could have death penalty on someone like that, like whether that punishment violates, I think it was in that they had framed it around the 8th Amendment, cruel and unusual and all of that. They're trying to draw an analogy, is what it seems like to me, between cases like that where we're saying, this should be taken into consideration as a mitigating or aggravating factor, and this situation with autism. But the problem here is we don't have a case like that has gone to, a Supreme Court level where you could draw that type of analogy. I agree with you. With both of you. I don't know how this could possibly be used as an aggravating factor. And the state is conceding. They're like, that's not our theory of the case.
Mm-hmm.
And that's not going to be our theory for punishment. So it might be much to do about nothing. The other thing is maybe they're putting this out in a, public hearing, so it's out in the world also, and to explain some of these behaviors that have been topics of conversation out in the community, right? We've all talked about, and it was mentioned in the hearing, his stoicism as he's sitting at counsel table, the way that he holds himself is very stiff. He clasps his hands in front of him. And these are all examples that were argued by Ann Taylor today on this motion. He's like, some of those behaviors, we don't, that are linked to his diagnoses, we don't want that to be misconstrued as some sort of aggravating factor in some manner.
Shout out to David Sarney. If this is the same David, which I think it is, he's a retired NYPD detective. The Raiders is what's throwing me off, but he could be a Raiders fan, and an NYPD retired detective. But shout out to David if it is the David, which I think it is. So Greg Skordas, I was going to ask you, I mean, should we expect a moment, FYI, Judge Stephen Hippler agreed to the defense request to ban the word, we're getting to that COE, psychopath and sociopath, from the trial. Those words will not be allowed, and we'll just talk about why, which is, I think, fairly obvious in a moment. But Greg Skordas, is there going to be a moment in time at this trial where Ann Taylor comes forward in a dramatic fashion and she turns to her client and says, ladies and gentlemen of the jury, you might notice that my client, Bryan, has his hands clasped in an odd way, and he might not make eye contact. This is because he is on the autism spectrum. This has nothing to do with the commission of this crime. Are we going to hear her come out and say that? I mean, how does the defense use this in their favor?
I think exactly like you just articulated, that maybe if he's got some quirky behaviors and she is feeling like the jury might be reading something into those that just isn't there, that she can explain that he's got some behaviors and that that's not to be taken into consideration in considering whether or not he committed this crime, that the person is who he is, and whatever sort of, mannerisms or expressions or motions that he makes are as a result of something completely unrelated to this. And as Taras explained better than I did, apparently, it's not an aggravating or mitigating factor. It's just a fact of the case. It's just who he is.
Okay, that saying it that way makes a lot more sense to me. Sky, to you, I mean, to Tara's point just now, she said, well, one of the reasons this may have come, and by the way, someone asked, when was he diagnosed? And we just heard about it recently. And as far as I know, we hadn't heard about any diagnosis, but who knows what the defense did. And I guess we're going to find that out in due time. But Sky, to Tara's point, was part of the purpose of this today just for the defense to get it out there further into, we've heard about it before, but so more people are aware of this. So when it does go to trial, because people watch podcasts, watch the news, they're going to say, hey, this guy is weird, but he might be weird because he's on the spectrum and he, lurks under doorways to protect himself or whatever it might be. Is that really what's going on here? Are they just setting this up for the court of public opinion?
I think it's possible. I mean, that might be one of their purposes. I could see that because you can put things on the record, through a legitimate motion that you couldn't otherwise just probably come out and say about your client. So I do think that probably, maybe played a factor into it. And I do think, though, I don't think it's baseless. I think, one, we're talking about a death penalty case. So the reality is you leave nothing unturned. If he wasn't diagnosed previously, it was probably right of his attorneys to go get a mental health, assessment done of him, so they know exactly, if he has any cognitive functioning issues or psychological issues or anything like that. But, to both Greg and Tara's point, if he was acting weird during parts of the investigation or the interview that we might possibly see, or I think they ruled on some body cam footage today from a traffic stop or something along those lines that they're going to show parts of. Really, all that is character evidence. It's not evidence of guilt or an element of the crime. It really boils down to character evidence. And I think what, at least, and my impression of maybe what the defense is trying to do is saying, look, in the trial phase, this shouldn't be used against him as character evidence, or the way he acts be misconstrued by the jury as somebody who doesn't care. I mean, we watched the Lori Daybell trial up in Idaho, and there was a lot of comments about the way she acted in the courtroom and her mannerisms. And so, I don't think it's misguided at all to bring the issue up by the defense.
Okay, that is interesting. Tara, one of the questions that a lot of people are asking in the chat is, are these defense motions ever going to end? I mean, we're getting to jury selection at the end of July, so that leaves like 3 months. I mean, to their credit, they're doing everything that they possibly can. There's no such thing as like a limit on motions, correct? I mean, the defense can file motion after motion after motion. What does the law say about that? What is the protocol? Does the judge have to hear them all? How does that work?
So in every case, you get a pretrial scheduling order. In cases like this, the parties agree to that because it's a big case. It's a death penalty case, and it's a big case for other reasons too, because there's a lot of, as we have heard about, discovery that had to be exchanged between the parties. So this court, judge initially put out a scheduling order. This court then, when there was a change of venue, and this judge who got the case met with the parties and made some changes to that scheduling order. So there were timelines in there for discovery. There were timelines in there for motions in limine. There's timelines in there for exhibits and witnesses. Things may change and they may develop. As we heard today, there's a massive amount of information that the defense is still trying to get through. And so, there may be something that comes to their attention that they don't know about yet, and they will file a motion and ask the court to address it. So in rule or in statute, is there any sort of like limit, like you get 10 motions and that's it, you're done and you're out? No, there's not. The judge controls that, and the judge controls the calendar. Will it end? Yes, probably at trial. Maybe. I mean, there's, motions you make in the midst of trial too, because trial is unexpected and unexpected things happen every time. But what I would say is this is exactly what the defense should be doing. This is a death penalty case. It's a really serious case. If they don't raise an issue, by and large, the general rule is if you do not raise an issue at the state court level, at the trial court level, you can't raise it up on appeal. And so they have to do a very thorough job of making sure that they are properly defending Coberger's rights and his right to a fair process and a transparent process, and making sure that they're getting all the information that they need to properly prepare to defend this action. So I don't think it's unusual.
Yeah, and they're doing their job. There's no doubt about that. And Chelsea Whitaker here makes a good point. I know she's been following this case very closely. There are equally as many motions in limine from the state, just saying. So, people tend to gang up on the defense. The defense, say again, Sky?
We're an easy target. It's fine.
The defense stepped in it with the AT&T records, according to Ohio Palm Mom. This is another great point here from Aria Dakota Grimaldi Lane, one of the best names anywhere, not just the YouTubes. He is super intelligent. Otherwise, he wouldn't have been able to cope with being a PhD student and a teaching assistant. If he does have autism, surely there would be some more noticeable symptoms. I mean, we don't have any psychologists on the panel, but I mean, Greg scored us just to that point, and then we'll switch to the next motion that was discussed today. But and there's a lot of them. So, by the way, this is not going to be as long, I don't think, as a typical show, because I promised the guests that, but we'll get through a lot of what was discussed in court today. But Greg, the state is going to say, hey, this guy, if Ann Taylor brings it up and says this guy is maybe awkward and weird, the state would likely have to get up there and say, look, he might be awkward and weird, but he was also a PhD student. He's written papers. He was teaching people. He's very capable, very high IQ. Is that something that the state would be allowed to bring up?
Yeah, I think so. But to the defense point, Joel, we think of autism as a spectrum, and we think about a person having a sort of a range of autism, that some are very high functioning, some are PhD students, some are doctors, lawyers. I mean, people can thrive and do very well with different levels of that. And I think the state's going to make what they can out of it. If the defense tries to use it as in mitigation anyway and say, hey, don't worry, he's got these problems, he's got these issues, the state's going to say, yeah, but he's like you just said, he's a PhD student, he's very, very bright. And I think it cuts both ways. And so that's why really at the outset you mentioned, and I think both Skye and Tara have sort of chimed in on this, that it's maybe the autism is more of a non-issue than it is an issue for both sides, because it doesn't help or hurt either side more than the other. It is totality.
I wonder if it's an aggravating circumstance for a podcast host to be awkward. So I'm definitely guilty. By the way, Greg, I have a question for you, because you've been doing this the longest out of the three guests. Did judges like their job generally? Because most of the judges I see look like they want to jump off a cliff. Especially, the Lori Vallow is kind of understandable, but a lot of these judges look like they're not happy in life. They get cool license plates. They get great perks. The criminal defense, the Skye Lazzaros are making all the money. Are they happy, Greg Skordas?
Judges take a sacrifice, Joel, to become a judge. They're usually very, very successful lawyers. I serve on a commission here that selects judges for parts of Utah, and there's so many people that applied to do that. I think they love it. I really do. But it can be, I wouldn't apply to be a judge, because they're so reactive. They can only react to what's in front of them. They can't make motions themselves or ask witnesses questions themselves generally. So my experience with the judiciary that I've dealt with, and I've seen judges in many states, is they really like their jobs. They do it for a reason, and serving the public is what they like to do. And you're talking about motions in limine, which probably drive them nuts. But boy, when you get into a trial and everybody's moving along and the judge is driving the ship, I think they really get into that and enjoy that part of it.
Skye Lazzaro, I got to ask, if you were appointed as a judge, if someone said, hey, Skye, do you want to be a judge? Would you accept? Is that something that you'd be interested in? I could see you in the robe up there. No. Skye has a Porsche, and she wants to keep that Porsche.
Yeah. No, listen, I agree with Greg. Most of the judges I know, they are firmly committed to, being public servants. And a lot of them here come from, very good law firms and have left private practice to go do it. I would not want to be a judge for the sole reason is I would die with the inflexibility of the schedule. I'm fine with working, but I'm just not sure I can do it from the same place every single day.
Yeah, that's a good point. Although I got to say, there are more breaks in court than anything I've ever seen. Vallow starts at 10:30 local time, and they were done today by 4. So makes banker's hours.
I don't ever get that lucky. I don't know about Greg, but my days don't generally go that way in trial.
All right. So now that we know that judges do like their job, I feel a little bit better for these judges. But one of the motions today, or one of the developments, I should say, that kind of came out, the defense confirmed that Bryan Kohberger's family may be called by the prosecution. But they went on to say, Tara, that the family has zero interest in helping prosecutors. They say that his family loves and supports him, and that the only reason they have not been in court to support them is the high travel costs there in Pennsylvania. To get to Idaho is difficult. What is this about with the defense going on the offense here to say, yeah, the government might call his family. They don't want to do this. They'd be forced into it. Is this also like a like a court of public opinion tactic to say, yeah, they don't want to do this, or they're doing this begrudgingly?
No, I think this was actually related to a motion in limine about what family members could be in the courtroom during testimony. So what happens normally is when you have a trial, there will be a motion, or the judge will do it on his or her own, and will have all witnesses not be in the courtroom to hear the testimony of other witnesses until they are done testifying. And so we're isolating testimony, or not, mixing it all up so they hear how someone else is saying or what their recollection is. And so the question, victims have a right to be in the courtroom, and victims' family members have a right to be in the courtroom for the entirety of the trial, so they can listen to other people's testimony. Experts can be in the courtroom for the entire trial, generally, especially if they're going to be opining and rebutting other expert testimony. But the question here was, if the state is going to be calling members of sit in the trial and listen to everyone else's testimony before they have testified. And so that issue was brought up by the defense, and there was a back and forth with between the judge and the prosecution team as well. And it was, the judge's question was, are you planning on calling some of them? And they talked about how do we preserve and maintain the testimony, in a way that we're not having kind of this cross mingling. I don't know what else to call it. And so one of the ideas that came out was, or was proposed, and I can't remember if it was the judge or the prosecution, was, you could potentially take those witnesses out of order. So put them on first in your case in chief, and then they can sit in for the remainder of the trial if the state is going to call them. So that portion of it sounded a little bit more like they were trying to problem solve, or the judge was trying to help kind of problem solve on how do we do this. The defense's position was, Coberger is very close to his family. They're on his team. They believe in him. And he absolutely needs their support in the courtroom. And they're very close, and that's why they should be allowed. There's a human aspect. Humanity was the word that they used. The humanity of the situation.
Yeah. Well, Greg Skordas, by the way, Gia and TJ's mom, from what I've seen, his sister was very suspicious of him. Why wouldn't they call her? I vaguely remember, like, after this all broke, that she lost her job because she was his sister. It was a very troubling development. But Greg, to you, what are, I guess, the potential risks for the state and or the defense if they call the father and the sister up there? They've got, I always hear that there's a lawyer never asks a question without knowing the answer. But what if something is said that kind of opens the proverbial door? How careful let's start with the government. Do they have to be? What are their risks?
Well, I think the risk the government has is, especially if it's a death penalty case and you put mommy on the stand, going to tug at the jurors' hearts and talk about Bryan growing up and struggles that he had and things like that. I think that's a real risk the government doesn't want to do. In fact, I would assume that in the penalty phase, if the trial gets to that point, that the defense will put his family on the stand, will put his mother on the stand. Now, Tara makes a good point that the sister may have had some issues with him. And so if the government puts his sister on, who talks about maybe that he talked about doing something like this, or we know that he wrote about some bizarre similar things, that could be problematic for the defense. So I think family members, boy, in my experience, having prosecuted and defended death penalty cases, they're usually far more helpful for the defendant than for the state.
Sky, there you go. Better for the defense. So Sky, this is a sad comment here. My sister shot and killed her boyfriend in 1980. That's a long time ago. Not one time did I stand behind her or support her. She killed him. That harmed so many people. Takes a lot, and I'm sure that is impacted the family in unspeakable terms. But Sky, to you, the defense stressed today in court, and this I didn't get, that if prosecutors want this family testimony, they must subpoena them. I mean, don't you have to be subpoenaed no matter what to appear in court? So why was this made into, not, I don't want to say an issue, but it was something that was underscored that they would have to subpoena them. Am I missing something?
Well, I mean, we can call witnesses if they're friendly and they're on a witness list from the defense side, right? If they're just willing to come, right? We don't necessarily have to have people under subpoena. If you want to compel people to come who wouldn't otherwise want to be helpful to you, then the state would need to subpoena them. I think the point there being, the defense saying, look, they're not going to come voluntarily help you. Like, you can't send them an email and say, show up at trial. If you choose to subpoena them, then they're going to have to comply. But otherwise, they're not coming just because you asked nicely.
Vesper Martini, but one of the reasons I love hosting this show is I'm getting, at some point, I want an honorary STS law degree handed to me from Greg Skordas. I want to, and I will wear the gown on. Just don't make me a judge. And I also want to be an honorary FBI agent and a homicide detective. Those are my wishes. But a man can dream. So the state. The judge, Tara, and then we'll put a cap on this one and move on to the next one. Judge Hippler, who is kind of no nonsense, he announced that he's going to take this matter under advisement about the family testifying, and said that he expects the state to specify witnesses early in the trial. This is what you were sort of talking about. So are we going to get like a witness list up front? And to your point earlier, if they do call them, is the judge going to say, well, you got to call them very early on, if not the first people to call, so they can then sit in as people in the gallery just watching the trial?
So that's the issue that the court took under advisement, is how to deal with the situation of family members in the courtroom. And so we don't know the decision of the court on that, but yes, we will get both the state and the defense have pretrial deadlines that include their exhibit lists and their witness lists. So those will have to be submitted in advance of the trial. And again, as a reminder, the defense does not need to put on a case. The burden is entirely on the prosecution. They can decide to put on a case if they would like to. And so we'll see what that looks like. They'll probably have just in case people on there. But yes, so we simply don't know yet what that's going to look like until we see Judge Hippler's order on family members. And it could be that he does come out and order them to be taken out of order or, put on first by the prosecution.
Yeah. Sky, back to the kind of like the endless waterfall of motions being filed. We heard Tara say that basically you can just file the motions you need to file. And then you heard Chelsea Whitaker, who's a member of STS Nation, saying that the state has filed an equal number. I don't know if that's 100%, accurate, but I'm sure it's very close at the very least. But the judge today, Judge Hippler, he did seem annoyed by the defense. As a defense attorney, I know no one gets annoyed with you, Sky. You're too nice. You love horses. No one gets annoyed with you. But do you have to be careful? Is it just something that you get a read on after being a defense attorney for a long time? By the way, Sky Lazzaro's updo there, that so I wouldn't call that a bun, but that's sort of how I picture Ned Smith. But we have someone in STS Nation who I've never met, and Ned is a woman, and I picture her having a kind of like a big old hair bun. So Sky Lazar is reminding me of that. But Sky, I digress. So Sky, what is that a read that you get being a criminal defense attorney that, okay, I've pushed this judge as far as I can, I got to back off now?
Yeah, I mean, I think so. The reality is, as we've kind of mentioned here before, when you have a death penalty case or some sort of aggravated murder case, you have to preserve issues, and you know that there are going to be things that are going to annoy the judge, but it could be a potential, appellate issue down the road, depending on what happens at trial. And if you don't raise it, it's waived and it's gone forever, unless you were so ineffective that for some reason the case comes back. So I think it's always a balancing act of, filing appropriate motions, preserving the appropriate issues, and not filing frivolous things that are going to annoy the judge. Same thing when you're arguing. I mean, you can get a read on people. If you're up there arguing and it's clear that they are done listening, make your points and sit down and not continue to belabor the point. Whether it's going your way or not going your way, you're not going to get yourself anywhere by continuing to annoy the judge. And judges are human, and despite, I think they all do the very best they can, the last thing you want to do is kind of always be the annoying person in the room, or have judges think that you're not bringing things on a good faith basis, or you're just making arguments for the sake of arguing. So I think it's a balancing act, and I think it's kind of case dependent as well.
Sam M's asking, so the court is actually streaming, I believe already, but they're going to be streaming the trial, the court itself, because they don't want, and Tara's watching, so she's shaking her head in agreement. The Ada County Courthouse, I believe, has their own YouTube channel, and they are streaming it. But when Sky was talking just now about kind of getting a read, being a criminal defense attorney, I've learned, is a very difficult job. It's 3D chess, if not 5D. It's hard. Like any good person in their profession, it takes a lot of work, and that is never been more evident than watching Lori Vallow defend herself. It is like Chinese water torture. I don't know if you're still allowed to say that, but I just did. But it is torturous, and she clearly doesn't have a real command of, she's playing a lawyer on YouTube these days, but to be a smooth, good, effective criminal defense attorney, you got to put in the hours like these three. You can't just get up there. There are levels to the game, and the government is making her look pretty foolish, which I think is going to be to her detriment with the jurors. But okay, so on to the next thing here. There is a battle over words, Greg Skordas. Murderer, psychopath, sociopath. The COE put a thing up about that earlier. The defense has argued that the labels are inflammatory and prejudicial. The judge did rule, saying that terms like psychopath and sociopath will not be used unless there's a valid psychological evaluation. So, Greg Skordas, I assume this means that the state would have to bring in someone like a Dr. Ann Burgess, a legendary profiler who's on our show, to go in there and say, this guy exhibits all the behaviors of a psychopath, and he checks all the boxes. Then it would be allowed to be used. That is obviously something the defense does not want to happen. Do you think we'll see that word tossed out, psychopath or sociopath?
Yeah, I think so. They're inflammatory, although that's not necessarily the threshold question. But there may not be relevance to that. I mean, what does that have to do with? I mean, the crime speaks for itself, and it's a horrible crime. Whoever did it is a very, very evil person. But to try to pigeonhole him into some, it's almost like the autism thing. It's just you're trying to put some character trait on him to try to define him, when the jury has to listen to the facts of the case and make a decision. So if he's a psychopath or sociopath or, I don't know, how does that help the jury in a finder of fact? How does that help them do anything to make a decision as to guilt or innocence? And again, back to what you said in the question itself, was there some diagnosis to that? Is there somebody that is willing to say that based on some sort of a clinical analysis? I just don't think that's there. And so then it's, I won't say name calling, but it's really just trying to belittle him in some way that's not necessarily relevant to the facts of the case.
Yeah, and Greg, I think you and I discussed this, that creepy selfie that's reportedly taken in the early morning hours after the roommates were murdered. Real Plant Diaries is saying all you have to do is show his selfie. How early on do you think they'll put that selfie on exhibit by the government?
I'd post that in my opening remarks as the government, and forget the sociopath and psychopath. Let the jury come to their own conclusions, because that is a creepy picture. I mean, I'd show that every chance I could during the trial if I was the state. Yes.
And so will we. We'll show it every chance we get. Yeah. And you can see a little portion of the shower curtain on his left side. The thumbs up, very pasty and just weird looking. The government, I think, wants to use this because it plays to the description from DM, one of the surviving roommates, about seeing someone with bushy eyebrows. He looks a lot thinner here. He just doesn't look like the most healthy individual, but that is for another time and another discussion. Tara, to you, while we look at this for another minute before I get nightmares. Judge Hippler said, look, I'm not going to issue a blanket order barring prosecutors from following quote unquote standard rules. He says he expects professionalism. The judge says that he acknowledges that the crime was brutal and horrific. And to Greg's point just now, that the evidence is going to reflect that. So the way I understand it, the judge is basically saying, yeah, if it's sort of a medical diagnosis that he's a psychopath or sociopath, it's okay. And I'm not going to tell the government exactly how to play this, but they need to be professional. But ultimately, when they hear what happened, that's going to be enough. Do I understand it correctly? Is that what he's essentially saying?
Yeah, what he's saying is, I mean, there is a lot on the line for the prosecution as well. If they make a misstep, if they start going down the road of labels, and appealing to the passions and the prejudices of the jury, they are risking everything. They're risking the entire trial. And so there's a lot of incentive, I think, on the state side. It certainly was when I was a prosecutor, to mind your P's and Q's and make sure you're not stepping over any of the ethical lines, and you're not getting into the territory of prosecutorial misconduct by doing or saying or labeling in a way that you shouldn't. And so the judge's warning is, I take it as just that, which is, everyone is aware, you're all professionals and adults in the room, and you know where the lines are. And we're not going to go nitty gritty down each and everything that could possibly be said here. But, there's proper conduct and a proper way to conduct a trial as the state, and there are improper ways. And, to Greg's point, how does that move the ball forward? It doesn't. I mean, the facts of this case are alarming and, horrible. And so that alone is going to carry the case forward. I don't think slapping a label on there is going to help anybody.
Devo Bronk here. Defense counsel was literally telling the judge what to rule on several of their motions. Not good. That just goes back to, you don't want to irritate a judge, even though they love their job, apparently, even though they don't look like they do. But here, this is a perfect example. This person, Sohn Blink, welcome, by a lot of new names, and welcome to the previous one, whose name I already forgot, Devo Bronk. But you look at it right here, he's such a loser. Look at him in that picture, which is this. I mean, this is going to potentially be the thought of a juror, and that clearly is not going to help his defense in any way. So, and this is interesting. It's only creepy if you already think he is the killer. I don't know if that's true, Van Paul. But I do like your shades. I don't know if that's true. So prior acts, onto other stuff here, Amazon purchases, traffic stops. So the defense argued that Bryan Kohberger's, and this came out again not that long ago, a 2020 college essay where he kind of talks about, he writes sort of about a very similar crime, about a stabbing. So that and Amazon purchases should not be used as prior bad acts. Sky, I don't understand that. Oh, look at this. I didn't even look ahead. But the judge disagrees, saying that purchases and Amazon are not bad acts. But these things seem very pertinent to the government's case. What about this 2020 college essay and the Amazon purchases? Apparently, he bought a K-bar knife, which is the weapon that was used. He bought a knife sheath. He bought a replacement knife sheath. How could that be suppressed? That's so key to the case, isn't it?
I think they're two separate issues. I think the Amazon purchases are probably fair game. I think that, the hard part is anything a defendant does is probably fair game because it is either something they did or said. If it falls under these other bad acts, falls under 404B, which is essentially uncharged criminal conduct that's generally excluded unless passes a test to be relevant to the case. So I don't think that the Amazon purchases even come close to that. I think those come in. I think the judge is right on that. I think the writing is a little bit interesting. We get into this in a lot of cases where people have, written essays or poems or, whatever it is that, we try to exclude as not being relevant to the case because, maybe it's fictional or it's going to be more, inflammatory to the jury than it is going to be, helpful to try to prove any element of the crime that's charged. But like I said, I understand why the judge let it in, given that, it's comes from the defendant's own words. And unless there's some privilege attached, it probably comes in unless you can win on a relevance argument.
Look at this comment. Tara, I don't know if we caught this because we went on air. From Jeannie Crime Junkie here. That judge is very unhappy with the defense. In their last argument, they said if the judge does not take the death penalty off the table, they will not meet the trial date. Threatening Judge Hippler. I don't think we saw this because this appears to have been one of the very final things of the day. Probably pretty bad advice, I would say, to tell the judge what he's going to do. And threaten in that way. Tara, is that how you see it? Or is that potentially smart move by the defense to threaten a continuance?
Well, threatening a judge generally is a very bad idea. Would not recommend, especially as an attorney. That'll get you disbarred. Pretty sure about that one. So no, you shouldn't do that. I think there's, and I didn't see this part. So, but what I will say is that when you go in and you file a motion, you have to be really direct about what you want the judge to do. You're saying, hey, judge, I'm filing this motion. I'm making a request. This is what I want you to do. And so there was a lot of back and forth on that today, where the defense was saying, here's what I want your order to say. Here's what I want, the outcome to be when you decide this. So that's not improper. That's actually permitted. That's what you should be doing. You should be really specific about what you're requesting the court to do. I think the arguments around that death penalty, and again, didn't see this part, but the arguments around the death penalty and is related to, in this instance, related to discovery. They're saying there's a lot of discovery, that the discovery wasn't organized in any way for the defense, and that there's, that they have a lot to do before this trial, and that death penalty should be taken off the table because of discovery violations by state. So including non-organization of the discovery and then previously, it was like they hadn't turned over. There was an allegation that they hadn't turned over everything they needed to turn over. This comes from, for those who watched the Vallow case, the Lori Vallow case, this was a discovery sanction that the judge in the Lori Vallow case issued, and said that there was a last minute, and I think may have been like telephone calls. I'd have to go and remind myself of that, but it's like telephone calls that came out at the last minute. It was, very shortly before trial in the Vallow case. Lori Vallow had not waived her right to a speedy trial. And so that was a big difference in the case, because she, as all defendants do, they have a right to a speedy trial. They have to be brought to trial within a certain period of time. If you waive that right, like you're asking for a continuance, usually the continuance is conditioned on waiving your right to a speedy trial, meaning we now don't have that timeline, that same clock in the same way. It's different here. Bryan Kohberger waived his right to a speedy trial. He did it earlier on. And so we don't have that same time clock. And so these circumstances are really different that we're under versus what was going on with the Lori Vallow case. So they could, the defense could come forward and, it's getting closer to trial and say, we need a continuance because we haven't gotten through, the 64 or whatever terabytes of discovery that has been presented to us. And the court will hear those arguments and figure out whether or not to bump this out again. But anyways, I think that was likely what was happening.
I think if I'm right too, that the defense already went down like the Lori Vallow, they invoked the Lori Vallow Daybell trial saying, hey, but to Tara's point, it's like apples and oranges. But Vesper Martini here, the judge did not want to hear it, told her to ask for 10 more paralegals. That's Ann Taylor. Sky Lazaro, I was going to see you and Greg, I think, in Utah because I was coming out for Corey Richens. That got continued. Is this trial going to happen end of July with jury selection, or is Ann Taylor going to drive this Judge Hippler nuts and he's going to have to continue it? What do you think?
I think it depends. To the point about discovery, it also depends on when the discovery was turned over. If we're this close to trial from, something that happened in late 2022, and we've got trial set in a couple months and the state's had stuff that they've been sitting on or they haven't turned it over, and all of a sudden they dump it on the defense in a death penalty case this close to trial. There's a couple remedies, it's one of them is a continuance. Another one is the exclusion of that evidence. And potentially, a sanction such as, removing the death penalty. I don't see that happening in this case. And I don't know what the exact context was surrounding the discovery. If they've had the discovery since the beginning of the case, then, that's a little bit, they set the trial date, they were part of that. So that becomes a little bit of a tougher argument to make. But then I think judges also balance, this is a death penalty case. Do I want to build error in when I have defense counsel essentially telling me if this goes forward as a death penalty case, I'm basically going to be ineffective. Really, that's what it comes down to. And I don't think it's a threat. Maybe it's just them being candid and the way it came across wasn't good. But, they are putting him on notice that, hey, we won't be ready for whatever reason. And maybe it's because there's so much stuff and they don't have the manpower or, whatever it is, it's probably better to bring it up now than the week before. So, I think it's a little bit of the judge is going to have to balance, kind of all those competing interests. Because if they're saying now we didn't get through all the discovery and we're going to trial on a death penalty case, I don't know what else is ineffective, but that's not good. So
yeah, definitely not good. By the way, huge shout out to the mods. We've been going all day because we're doing the Lori Vallow Daybell stream. Can't do it without the mods. They're awesome. Shout out to Space Coast on the West Coast, to COE, who is the glue, and Steve Cohen, Meave Moen, who books the best guests in all of true crime. If you appreciate the content, please hit that like button. That's not that hard. Sub. We've got a Patreon page to support the channel. we've got a second channel at STS Talk, that we are building up slowly but surely. So Greg Scortis, another issue, and I promise we'll get through this quickly in the next few minutes here. There was sort of widely seen body cam footage of Bryan Kohberger at Pullman at Washington State University, arguing essentially after being pulled over about his rights, about the intersection, and it goes on and on. Thank you, Abby Crossing, for this. Much appreciated. So it goes on and on and on. He's arguing, well, technically, according to Rule 17B in the state of Washington, I'm allowed to have 3 inches of my bump, whatever he was saying. The defense objects to that body cam footage, and their argument is that it connects him unfairly to the white Elantra, I think it was, to the white Elantra. The judge said he finds it relevant, but may redact parts after reviewing the footage. It sounds like that video is coming in. What would he have to redact, I guess? What would need to be redacted from that?
Just the dialogue. I mean, really, if the state's using it to show his connection with the Elantra, that's fine. But if they're using it to show how miserable he is, or how horrible he is with the police, or I don't know, I hate to use a bad word, but just what a jackass he is. That's what we talked about earlier. I think it was Sky was talking about, prior bad acts, to show that he's a bad person, that he's a contemptible person. The judge might say, look, we can show him in the car, we can show him get pulled over, but the fact that he's being disrespectful to the police is not relevant to this case, and it may be prejudicial. It may be unfairly prejudicial because it doesn't have the relevance, except to the extent that he's in the car, and the judge can redact the language, the bad language, and allow that connection to the car to come in without getting through all this dialogue that makes him look like a really, really bad person.
Aria Dakota Grimaldi Lane. This is an interesting comment, and this is where I scratch my head. With such terrible wounds, Tara, and the police department calling it a bloody scene, how could the roommates not know? And again, we have to be careful about victim shaming, because there's all kinds of studies on trauma. But I have another question. How would they not know that they were dead? Again, they didn't call 911 for a very long time. Just interested in the best guest opinions. But Tara, my question is, how, from what we know, there's just such little blood evidence for such a gruesome scene, and this was done in a matter of like 15 minutes. I just don't understand. Forget who did it. I just don't understand how it was done out leaving a whole lot more blood evidence behind. Do you have any thoughts on that?
I mean, a couple of things come to mind. One, recall that the person that was spotted by one of the surviving roommates was the way that they were clothed. They were clothed head to toe in all black. They could have had something on their hands, had a mask, and there was a very small opening where, the eyebrows and the eyes were exposed. So that could have something to do with it. The other thing is, again, we haven't seen any evidence, right? We're piecing things together from filings that are public, and some of them are not public. Some of them are sealed. So we won't know about the amount of blood evidence throughout this house or in other spots. We really don't know any of that yet because the state hasn't put on any evidence. All this is right now is just motion practice back and forth. So I would, I guess, caution people not to jump to a conclusion right yet, because we haven't seen anything, just like we didn't in the Vallow case. And, the thing that came to mind was the hair that was under the duct tape that was around one of the children's necks. Like, we didn't know that fact until the trial. And so my guess is we're going to be hearing a lot more information that will be surprising about the blood evidence, where it is and where it wasn't, as we get further along.
That's a great point. And I also do remember at the beginning, there were some photos that were, I don't know if they were leaked out or publicly released, but showed quite a bit of blood pooling and like seepage into another room. So like to Tara's point, we don't know what we don't know. But three more points here real quick. So Sky Lazaro, the defense on the topic of IgG, which is investigative genetic genealogy, they are pushing to refer to IgG as quote unquote just a tip, like they got a tip, as opposed to using investigative genetic genealogy. And the state agreed to this along with the judge, that they should keep the explanation minimal to a jury. I'm obviously, if I'm a juror, I'm not going to understand the intricacies of investigative genetic genealogy, but it's so much more than just a tip. Like they used a database and linked it to a family member, which then tied it back to Bryan. I mean, isn't that a pretty big deal here?
I think it is. There was a cold case in Utah that they used this type of genetic mapping to essentially find a suspect. And they did a talk on it, and it was fascinating because they have to trace it down all of these family trees essentially until they can isolate it to a certain family tree. It actually, I think, is quite in depth in how it works. I don't know if this is to get around experts. I know I also thought it was interesting when I was reading some of the stuff about today. I watched part of the trial or part of the hearings, but I didn't watch this one, where it was omitted from the probable cause statement. And they were, going to try to independently verify, that he was there or whatever. I think it's an interesting. I didn't read the motions on this one either, so maybe, someone else can weigh in a little bit more. But I mean, I think the most interesting part of the DNA part to me was once they found the touch DNA on the knife sheet, I think it was, they basically stopped looking for anybody else and admitted as much. There was other blood evidence that was, I'm assuming, was never tested or never put in CODIS. And so that to me is an interesting fact that they just, kind of admitted that look, we found touch DNA. And when you're talking about touch DNA, that's a whole other, issue of cross-examination and expert witness testimony that goes into that as well. So
Greg Scortis, is Ann Taylor in the process of calling Sky Lazar right now? Because she made a great point. She, are they going to argue? They're going to get Sky to come in and say, look, the minute this touch DNA was found, everything stopped. They had tunnel vision. They were only going after Bryan Kohberger. Is that something that we were going to see? Not literally Sky, but at least what she just brought up.
Oh no, absolutely. And if that's the case, it's a huge problem for the state. Maybe not insurmountable by any means, but if the state focuses, I mean, this is something we all do as defense attorneys. When we find out that the state has focused in on an individual, especially if it's our client, then we can argue that the alternative, which is to say, you didn't look at this, you didn't look at that, you didn't go here, you didn't go there. And that creates a great deal of cross-examination for your investigative officers to say, wait, once you found that, you quit your investigation and you focus solely on Bryan Kohberger from that point forward. You didn't look at any other suspects, any other individuals. That could go a long way. And a jury might think the same thing, which is, look, there's 4 deaths here. Maybe you do have a compelling piece of evidence for this particular individual, but you sure don't close the door and you keep that investigation open. And I'm sure that the police will say, well, we didn't shut it down entirely. I doubt they're going to say, well, that was it. We knew we had our guy, because that doesn't look good to a jury, especially with all the things that we're talking about, all the things that are available to law enforcement, the CSI, the DNA, the fingerprints, all those things that could still be looked at. And you have to make sure that you foreclose other possibilities, because if Ann Taylor can create reasonable doubt in these jury's mind that maybe they should have gone somewhere else, the jury's going to be looking maybe toward a not guilty verdict.
Yeah. Well, that'd be very interesting. I can say that. Genie Crime Junkie Defense said they found a lead that the state ignored and they're looking into it. So they don't have time for the discovery, but I guess they're going to go and investigate a potential homicide suspect. We'll see what they come up with. So, Tara, there's also an alternate suspects debate. The prosecution basically came out today and said that they're concerned that the defense is just going to throw out some names. That, you know, this person did it or that person did it. There was a lot of talk about the guys around the food truck. The defense said, and I quote, "We promise not to throw spaghetti at the wall." The judge here says he's going to allow some generic evidence, but warns against casually naming specific individuals. I mean, what would the defense need to use a name to say, hey, we think Joe Schmo did this? What would they need to have in order to say that out loud?
The argument today was around that. It was the state saying, we don't want to be surprised in the middle of trial and have you throw out a name, and all of a sudden we're scrambling trying to figure this out. So what they requested was an offer of proof. And that is a procedure where the defense previews what they're going to be putting on as far as these alternative suspects. And that would be done prior to the trial, and it would be done in a different court hearing. So that was the instruction by the court, was like, and the request, I should say, by the state as well, which was, you know, we need to see this in advance. They should have to meet some threshold before they can advance this type of theory in court. And so we'll wait and see what the judge's written decision on that is, and what procedure he lays out. But it would be like an offer of proof, which is it just means you're in a hearing, you're going, okay, judge, these witnesses are going to testify in this way. And they may even put up those witnesses in advance.
There's some names already being thrown out. There's a few people in the chat who clearly believe Bryan is not responsible for this. Abby, ha 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 ha. She's our friend. She's saying it's obscene that BK's DNA was found. She also wants the Menendez brothers freed, and she wants justice for Ellen Greenberg. So she's covering all her bases. If you don't know her, you should. Sky Lazaro is a very, very highly respected criminal defense attorney in the great state of Utah. All you have to do is ask Greg Skordas, who's equally admired in that state. And Sky is a lover of horses. If the Corey Richens trial ever happens, Sky, I want to be able to come and ride one of these horses.
Perfect.
And I'll have you videotaping me trying to get onto the horse. Which,
I'm in.
That'll either fix my neck issues or it'll make them a lot worse, one or the other. But so one of the last things here, the defense wants to, quote unquote, block the use of the term suspect vehicle 1 to describe the white Hyundai Elantra. Prosecution says that the expert analysis links this vehicle through location, timestamps, flow of traffic. The judge says he's going to allow the term and leave the determination to the jury. What is that all about? Like literally calling it suspect. What is it? Suspect vehicle. I just lost my notes, but it's, I believe it was suspect vehicle 1. Yeah. Suspect vehicle 1. Sky, that terminology, obviously it's like in a affidavit or something. So they don't want the terminology. They want them to say it's a white Elantra. This government saying, no, we're going to call it suspect vehicle 1.
I think you see a lot of these in trials that come through motions in limine, the way terminology that's used. I think they also discussed it as it relates to the DNA and some other stuff. But it kind of falls in line with the same arguments about using words such as sociopath or, psychopath or what murderer, whatever it is they're trying to exclude. I think what they're trying to do is take words out that could be inflammatory in any way to the jury or create an impression in the jury's mind. So using the word like suspect or things like that can create, maybe some sort of thought that, this had to be the vehicle or it had to be his vehicle or whatever it is, instead of just calling the car, whatever it was, the Elantra or whatever. I can see the judge though, in something like this, where that's how it's referred to in a report, allowing him to use that language. I don't know that language is really that inflammatory. Now, using a word like murderer or sociopath or something like that, I mean, there's case law where, jury verdicts have been overturned on appeal because of language that prosecutors have used that would incite some sort of feeling against a defendant that's unfair. But in this context, if that's how the report's referring to it, I don't really see it as that problematic, and probably, don't take issue with him allowing the language to be used the way it's written.
What is your horse's name there, by the way, behind
this
you?
one? This is Carlito.
Carlito. It's a good looking
Carlito's
boy.
in California these days.
Greg Oh, really? Scortis, do you have horses on your palatial estate in Utah?
I don't. We live up by a ski resort. And I was hoping, Joel, that the Richens trial would come while we still had snow so I could take you skiing right up the hill here. But it looks like it's melting quickly.
Skiing and swimming are not my strong points, but as long as you protect me from flying into a tree, we'll be good. So Tara Malik is a defense attorney out of Boise, Idaho. She's been following this case with us and is awesome to have on. I forgot you went to the University of Arizona undergrad, Tara?
I did. Yeah.
You did. Yeah. Arizona Wildcats. I was just there for the book festival, and then she went to the University of Idaho Law School, so she knows Moscow very well. As a matter of fact, the judge in the Vallow case is a graduate of the University of Idaho Law School, but he's got a couple years on you, Tara. He's the guy that looks absolutely miserable being a judge, but and I like the guy, I think. I mean, he seems like a nice guy. He just looks like he hates doing what. Maybe it's because of Lori Vallow. But anyway, so DM, who's a surviving roommate, she described seeing this masked intruder with bushy eyebrows. We saw that creepy shower selfie. The defense argues here that the surviving roommate DM was intoxicated and disoriented, and they're saying that media coverage has reinforced this this incorrect memory. Prosecution countered, saying that DM consistently has described the intruder across multiple interviews. She's the only person alive who saw the suspect. The judge said he's taken the matter under advisement. I am no lawyer, but I cannot see a scenario where this surviving roommate does not get up and testify. Do you?
No, I mean, I agree with you completely. I think they're absolutely going to testify in court on this. And I would also be really surprised if the court disallowed the term bushy eyebrows as a descriptor to not come into the trial. I think, the prosecution's point was that while the defense was kind of conflating, other statements made by the surviving roommate about what was a dream and what was remembered and wasn't remembered, the prosecution said, she was absolutely consistent every time about her descriptions of height, weight, build, and the bushy eyebrows as well. So, I would be really surprised if the court disallowed that to come in.
And lastly, Greg Scortis, formidable criminal defense attorney, as you just heard, out of the great state of Utah. The 911 call dispute and the 3D house model, and then we get through everything amazingly. The defense wants to exclude or heavily redact that 911 call where 4 people in the house are all talking to the 911 operator. They want to just have their own transcript given to jurors. The prosecution says it's okay that you use a transcript, but we want the audio in there. There's a dispute over excited utterance. The judge says he's going to rule statement by statement, but is going to lean toward allowing most of the call. Typically, we do see 911 calls come in. Is there a reason here where it might not?
I think after we heard that 911 call, Joel, it isn't really problematic. I mean, it's not like there were a lot of screaming and shouting. In fact, the one caller wasn't even sure that the woman that she was dealing with was dead. She thought she was passed out or something. But we've all heard 911 calls that are just gut-wrenching, that really give you the chills. And that's what the defense wants to avoid here. But that 911 call was very factual. Even the 911 operator was very to the point. Well, is she breathing? Can you see this? Can you see that? There wasn't a lot of blood at the scene. for various reasons we've talked about. It wasn't a particularly gory scene that was being described by the 911 caller. They were passing the phone to other individuals, which was frustrating the 911 operator. But listening to it, I didn't think it was really something that would inflame the jury or cause them to be upset at any particular individual. The kids were just describing what they saw. It was early morning, and they didn't really know what they were looking at that point. So I agree that call is probably going to come in, almost all of it.
Yeah, and then finally, Greg, the 3D house model. So this was a huge point of contention about, do you destroy the house at 1122 King Road? People were like, do not do that because you need the jurors to walk through it. Well, the prosecution, Greg, now says that they want to use a 3D model of the house as demonstrative evidence. The defense says, no way, it's inaccurate. The judge sees it, quote unquote, as illustrative and not evidentiary, and will likely allow for courtroom explanation, not as standalone proof. What does that mean? Courtroom explanation, not standalone proof. I think everyone knew that the viewing of this home was going to be a problem, and it appears that they are now arguing over that.
Well, I think what the judge is saying is, look, it's helpful to the jury. It can help them understand how the house was, but it's not to scale. It's not every piece of furniture isn't the way it was at the time. And the jury's not going to, even if the house was still set up and there and everything, the jury's not going to walk through it. But it's demonstrative. It's to help the jury understand the layout of the house, the various locations of the rooms, the entry and exit points of the house, not necessarily to get them to understand the exact layout of where every bed and every sheet was and every pile, every pool of blood. So if it's not prejudicial, it doesn't show anything particularly gory, and it's just to help the jurors get an idea of how the house was set up, it's probably helpful, and the state will probably be allowed to use it.
And IGG rocks for a reason. She is reminding us that this trial is going to happen in Boise, which is over 5 hours away from Moscow, Idaho. So maybe there would not have been any kind of field trip. It would have been a really long one. These are the victims here. You've got Kaylee Gonzalez, Maddie Mogan, Ethan Chapin, Xana Kernodal there. And this is heartbreaking, absolutely heartbreaking. Their lives had not even really begun yet when they were taken from us. The Gonzalezes have been very open about wanting the death penalty in this case. Other family members of other victims are mixed, but that is what it appears the government is going for here. And we're going to see how it all plays out. But the parents of these kids, and by the way, Ethan Chapin, for those who do not know, is a triplet. So his two surviving siblings going to have to live with that, which is brutal. So this is a brutal, horrible case. It's really about these people, these victims, not about Bryan Kohberger. We're going to see what a jury decides, and it will be, in my opinion, probably the most high-profile trial of the last probably decade, if not more. The world media will descend, I think, on Boise when this happens, and we will be there to bring you coverage. Huge thanks again to Lisa Cox for this, but also Greg Skordas, Tara Malik, and Sky Lazaro, because of Corey Richens' continuance. I'll have to wait to ride the horse, but we will do it eventually. Love you, America. I still kept them long. I didn't mean to. Love you, Utah. Love you, Idaho. And justice for the Idaho 4. We'll see you tomorrow. Live coverage of Lori Valadabel starting at 2 Eastern. That's what time these lawyers start working, and these judges at 2 Eastern. To be fair, it's really 1:30 because they're on a half-hour delay. We will see you then. I'll stop talking.